Kirstie Morphet has certainly not allowed the grass to grow under her feet since being elected to the Legislative Council just over a year ago. She's not shy of tackling issues like homelessness and social exclusion, and is not afraid of rocking the political boat to get things done. In tomorrow's LegCo sitting, she'll take the lengthy Justice and Home Affairs Reform and Miscellaneous Amendments Bill 2025 through its final stage, which should result in much-needed reform to our criminal justice system. Kirstie Morphet joins me now in the studio. The reason we're talking is ostensibly because the Justice and Home Affairs Reform and Miscellaneous Amendments Bill 2025 is going through the Legislative Council and being steered through in your capable hands. But we're also a year into your time as an MLC, so we'll come to that shortly. But first, the bill, and I think if I read out the short title of the bill, that would be half the programme gone. This is a very big bill, isn't it?
Yes, so it's a really wide-ranging justice reform bill that focuses on how our criminal justice system works in practice. It's about the administration, the clarity and the fairness, and it marks a real step forward in continuing to modernise the whole system. It builds on the original Justice Reform Act from 2021, and it aims to make the rules clearer, help the system work better day to day, and strengthen public protection and safeguards.
And it runs to 70 sections, or 70 clauses, to use the old terminology. That's a huge amount, isn't it?
Yes, and it covers a massive range of things. The bill's split into three parts. So part one is the introductory, as is usual with all legislation. And then part two amends the Justice Reform Act. And then part three makes a number of targeted changes to other legislation where it's been found that this is needed to support or complete the reforms and the aims.
And yeah, I mean, there's 16 acts that are amended by this. Set aside the main Criminal Justice Act. I mean, how do you go about preparing for something like this? Because if you're doing your job right, there's an awful lot of reading here, isn't there?
There is, and it's not just one time. So this bill has been a long time in the making. So I arrived in DHA approximately a year ago, and had to do a lot of catch up then, and then it goes out to consultation and further changes are made, so you have to keep up with the reasoning for the further changes and the arguments for that. So I wouldn't like to hazard a guess at how many times I have read it, but a bill of this complexity I have to take in chunks. I can't take it all in one go, and I find having the office where I have two computer screens and my laptop really helpful, because then you've got the act that you're looking at, the Justice Reform Act, and then the act that's amending, so you can ensure that it makes common sense, that the cross-referencing is correct.
Because, of course, that's really important. And despite all the best efforts of the officers that draft these things, mistakes occasionally do creep in, and you effectively it's your name on the order paper. You're the one that's responsible for bringing it through LegCo. Even if Keys has missed something, this is your chance to make sure that you make sure the legislation is right. It
is, and it's the core part of the role of being a member of Legislative Council, is the scrutiny of the legislation and trying to ensure that the legislation is as good as possible and for the future, not just for today. So, I mean, I do want to thank the staff of the department, the drafters, the courts, the Attorney Generals. This has been a real multidisciplinary approach to a bill, and there's so many people that have been involved and being consulted with it, and having that many eyes on it increases that level of scrutiny, which is really helpful. And I know it's something that the Minister is very keen on, to ensure that as many voices as possible are part of the legislation.
And what For the ordinary person on the street, what are the things that you think are most important for them to be aware of about this bill?
So that's a difficult one because there are so many important parts. I mean, it's important just that we're able to correct mistakes and enable the previous act to be enacted by some of the things. But for me personally, the youth justice aspect is very important, as I've worked in youth justice for numerous years. So when enacted, the bill will finally deliver that long-standing aim of 17-year-olds being seen within youth courts, which I arrived on the island 20 years ago and was told that was happening. So for it to happen will be absolutely great.
So what happens at the moment?
All 17-year-olds are seen in adult courts,
Right.
and it's viewed as an adult conviction. So obviously that has far-reaching implications. And whilst the adult courts on the island do try to take into account someone's age, maturity, level of understanding, youth courts are designed specifically for young people. It's designed to have a rehabilitative focus. It's designed to look more holistically at a person and what they may need. And that's where they should be seen, 17-year-olds. The United Nations Convention on the Rights of the Child states that as well. And it's something that a serious case review from over 20 years ago also highlighted. So it's not anything new. It's just taken a long time to get through the legislation. And the legislation also enables, if a youth is co-accused with an adult, it enables you to break that so that the youth can continue being dealt with within the youth courts, obviously only when that's appropriate. What else does the bill do? So the bill enhances the sentencing powers for summary courts up to 2 years, which will reduce the lists for general jail delivery, which are the much more serious cases, and getting ready for a trial can take a very long time. So it will hopefully speed up the justice process.
And compared with the UK, I mean, I know in the UK they've got a massive backlog in terms of trials getting heard, or cases getting heard. How big a problem have we got here?
I would say, so obviously I've worked extensively in the courts, not in the last year, so it's not as big a problem as it is in the UK by any stretch of the imagination, but it is still a problem if you're a person who is charged with an offence and it takes over 12 months to get to trial and then sentence. That's a long time for you to put your life on hold, for your family to put their life on hold, for the victims to put their life on hold. And, whilst we want justice to be fair and dealt with appropriately, there also is a need for it not to sit on the back burner. So anything, and the courts would like that process made simpler and the administrative processes that go alongside it, and that is a lot of what this bill does. And
from weighty matters like that, you move to things like amending the Shotgun, Air Weapons and Crossbows Act, or letting off fireworks in inappropriate places, things like this.
And these are all important things. So the shotgun legislation, that came from a Tynwald resolution following recommendations of the Social Affairs Policy Review Committee on Suicide Prevention. And it's particularly around the accessibility of firearms and weapons for vulnerable people. So it reduces the risks to them and to other people as well. So whilst they are in part 3 of the bill and almost standalone amendments, they all have their purpose. And
so how would that alter things? The new legislation, does it require weapons to be locked away, or what's
this one will require some regulations to be, I think it's a code of practice, and that will be written and in negotiation with the firearms committee that sits. I can't remember their name, I'm sorry.
That's all right.
And that so in a lot of legislation, the fine tuning is not written in the primary legislation, and that's for a very good reason, so that it can adapt with time, so that it can adapt with consultation and use. So a lot of the amendments carry the ability for court rules, etc., things like that, to be written within secondary legislation or regulations.
And things like the fireworks. I mean, I know we've already had some fireworks. Oh, it was the 2004 Fireworks Act. I remember it because I was in the Keys at the time, and that was really to try and limit the times when fireworks would be let off, because particularly in the towns, they could be a bit of a nuisance and a risk to pets. So what's being added to on
so
this?
This adds some of the how you can give notice and takes into account how times have changed, and we can give notice now on social media in different ways. So it takes that into account, but it also adds in the very important aspect of livestock, which has been an issue that's been raised repeatedly. I know it was on Facebook this year a lot as well. So it broadens the scope, both how you can give a notice, but also to who you may be harassing or causing distress to.
Another one which I imagine would be of interest to you will be the Domestic Abuse Act 2020 amendments. What do those entail?
Well, this is a particularly important part. So there's some more technical stuff about domestic abuse protection orders and taking terminology out to make it read better and not... That's technical amendments.
Yeah.
However, this is more about protections for victims and witnesses. And so in certain cases, such as sexual offences, domestic abuse, and cases involving child witnesses or victims, defendants will no longer be able to personally cross-examine the complainants. And having supported two young people through cases in courts where they have been cross-examined by their alleged perpetrator, the level of re-traumatisation that goes on and the fear of having to face that is very substantial. And obviously it's a really good thing that can't happen anymore. It doesn't mean that the alleged perpetrators don't get the right to cross-examine the courts if they refuse to instruct an advocate. The courts can allocate an advocate to cross-examine the witnesses or victims on the alleged perpetrator's behalf. So it's still fair and equitable justice, but the level of protection for victims and witnesses is much increased.
Because I imagine that must be a hugely traumatic experience for a victim to potentially be cross-examined by the person who perpetrated the crime.
The strength of victims, the victims that I have worked with, never ceases to amaze me. Yes, we need a process to ensure the correct people are being punished and dealt with for their offending, but the process is long, it is bureaucratic, and you do end up having to relive repeatedly what has happened to you, whether that's within the police station with your advocate and then within cross-examining. So yeah, the strength of victims and witnesses is immense, and anything we can do to support them should be done.
I imagine that this is one of the reasons why so few prosecutions are successful in relation to some of these crimes relating to abuse and sexual offences. Certainly we've heard from the students who took part in the International Women's Day debate about the inequity of crimes against women, how poorly they appear to be actually leading to successful prosecutions. So this is a big issue, really.
Yes, and obviously that's not just a simple issue. That there are a multitude of reasons that victims may not continue with a prosecution, may not go through the court process as well. The level of evidence that's required for prosecutions is obviously very, very high, and there are multiple reasons, and this bill can't even begin to cover a lot of them. But where the department have been able to make changes and where the courts have been able to recommend changes, we have taken the opportunity to make those changes. And obviously we have the review that's started on the Sexual Offences and Obscene Publications Act. And that will be looking at the processes, how the legislation works. And I would urge anyone that can to take part in that review, because, as I said earlier, it's only by getting as many people involved in these reviews that we can make our legislation as good as we possibly can.
Are there enough staff in the Department of Home Affairs to cope with all this?
I've been lucky to work in a number of departments, and I would say in many of the departments, the staff dealing with the legislation and policy are not enough. And I would also say the staff dealing with the frontline work is not enough. So the staff within the Department of Home Affairs have combed through this legislation. They have lived and breathed this legislation for over a year, way before I became involved, and they are to be applauded. And the drafters, of which we do not have enough either, because this bill has been back and forth with amendments and changes, even down to on Tuesday when Mrs. August Phillips kindly moved some amendments that the government wanted to move. And they work at very short notice, at high levels of stress, and I can only applaud them for the work they do. But as I have stated in Tynwald, the amount of legislation that has come through this administration hasn't been as was hoped for by all of the departments, and there is a rush at the end, which I think the drafters are struggling with the level of work that is required.
And we could easily spend the rest of this programme and maybe several more programmes talking about this piece of legislation, because there is so much in it, and sadly all we really have time for is a kind of a quick overview. But it's not just this that you do as a member of the Legislative Council. No. And you've finished now your first year. You're just embarking on a second year. Is it what you expected, being an MLC? No.
I expected this part of it, the legislation part of it, and I'm very lucky that I enjoy this. I love the scrutiny, I love the research. I really enjoy this. The other things that I've been involved in, I haven't expected to be as involved in. I was very lucky to go into the Department of Home Affairs, and I think the staff there and the minister and the other political member have given me a lot of support, and I've had to learn whilst running, and that's been really helpful because I had the extradition bill as well, which was a very technical, complex piece of legislation. But also they've helped me realise that my 25 years of practice as a social worker are valuable, but I'm not a frontline practitioner anymore. And that's been a very hard change in my head
and that
to get
is
round.
Yes. That is particularly when you know so much about a particular area, because you have to remember that actually you're trying to represent all views on a particular issue, not just the view of the hard-pressed social worker who wishes that the powers that be would only listen and get things sorted.
Yeah, there's definitely a balance. I've always been an advocate for my clients, and I will continue to do that and have continued to do that in my speeches in Tynwald. But there is a balance, and you can't have a fight about everything. So I was also asked to be vice chair of the post office, which is not my area of expertise. So another very steep learning curve moving into the world of business. And then very recently, a month ago, I was asked to go into the Department of Infrastructure, with particular focus on housing and local authorities. So the housing obviously is an opportunity to have a voice, and I couldn't say no to that. So that's very new. So again, I'm now learning how a whole new department works, and they all work very differently. So yeah.
And in terms of the post office, obviously we had a debate in March Tynwald, and that was a lengthy debate, and everyone was demanding the blatantly obvious: we must retain our post office services across the island, and how are we going to enable people to access all these government services that are now becoming increasingly digitised. But there seemed to be a general agreement that something needed to be done. It's less obvious what that something needs to be.
Yes, I mean, obviously, as a social worker, that's been part of my role. I have supported clients who are excluded digitally, socially, financially for the last 25 years. And it isn't a simple one approach fits all. And that is something that I hope the Cabinet Office will look at, that it isn't just a question of car licenses or forms being online. It's the reality of they might have a mobile phone, but how do you fill out a 30-page form on a mobile phone? How do you afford the internet access? How do you understand how to fill out these forms? You've got attention span, you've got cognitive functioning, you've got the ability, you've just got the equipment. I mean, I could never fill out a DLA form without a laptop. I couldn't do it. I used to do them on a weekly basis. Yeah. So how anybody would fill them out on a small phone, I don't know. So yeah, it's a much wider. It seems to be simplified sometimes in the debates, and it's a much wider issue than that. And
it is good, I think, that everyone recognises that something needs to be done. So that at least is a positive. But then deciding what that something needs to be is the much more difficult bit, isn't it?
Yes.
And often that's the case in politics.
I think that's the case when you're dealing with human beings. I think politicians sit at a distance, as I now have been for a year, so things have moved on in a year. But we're dealing with the real lives of individuals, and that's what they are. They're individuals. They're not a homogenous group of digitally excluded people or people with a disability. And to make legislation and to create policy that suits everybody's needs is almost an impossible task, and it's about doing the best you can in the time frame you have with the resources you have, I suppose.
And of course you also have a whole range of different opinions and political philosophies, and ultimately the way in which our system has worked reasonably effectively since the ministerial government system was introduced was by everyone agreeing or trying to reach a compromise, which means that you end up with something that's in many cases not ideal, but it's what the most people are prepared to agree to.
Yeah, but that's the same in a lot of social business work relationships. You have to compromise, because for one person to have ultimate power is not the best way forward, as we are seeing in many different areas of the world.
Yeah. Well, I couldn't argue with that point, certainly. What what's the thing that you've enjoyed doing the most? And we've only got a minute left, really, but...
I've enjoyed the legislation the most. And the research, the background for policy, the work I've done on homelessness. I put together a presentation for Tynwald members that involved a client coming in and talking, and I found that was really great to have. The lived experience actually within Tynwald was brilliant. Getting my unanimous motion voted through unanimously about bringing forward the homelessness legislation, and the opportunity to work with the civil servants who have been creating the policy, the legislation. Their passion is great to work with.
Well, thanks very much for coming on the programme, and good luck with the next 4 years.
Thank you very much. I will need it.
That was Kirstie Morphet, MLC. So what do you think? Should MLCs confine themselves to behind-the-scenes legislative scrutiny, or should they be nipping at the heels of the MHKs to encourage them to get on with the delivery of the promises that got them elected? Perhaps a bit of both. Certainly the very lengthy bill that reforms our processes and systems of delivering fair and equitable criminal justice is a big step forward. Don't forget, this programme is available as a podcast. For now, I'm Phil Gorn. Gora Maius on Geistachrom. Thanks for listening.